Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Greetings, fellow legal minds. You may have noticed a change. We are now Just Verdicts. Formerly Trial and Medical Error, our podcast is undergoing a transformation. We're zeroing in on what truly matters: the strategies, stories, and mindset behind remarkable jury verdicts. Please join me as we dissect the anatomy of legal triumphs, spotlighting the lawyers, jurors, and narratives that shape courtroom outcomes. From pivotal cases to insider insights, we're here to fuel your passion for the law. So, to all trial lawyers seeking inspiration and knowledge, welcome to Just Verdicts, where every verdict holds the keys to success. All right, so this week we are talking to Tom Bosworth of Bosworth Law, who I'm super excited to talk to. And, Tom, sort of starstruck because, as I was telling you before we went on here, I feel like you do such an amazing job of top-of-mind awareness. Everywhere I look on LinkedIn and different social accounts and Legal Intelligence or in different magazines, I'm always seeing you, and I think it's awesome, and it's great to meet you in person, and I really appreciate you talking with us today.
Thanks for having me, Brendan. It's awesome to be here. Yeah.
So I want to go back in time for a second. I want you to imagine this, because I know a lot has transpired since, but I want you to imagine you're back in law school, okay? And I don't know about you, but I was broke as all could be in law school and was just, if I could just get, make $100,000 one day or something like that, that would be just unbelievable. I could pay off my overdrafted bank account and so forth. So you're there, you're getting through. Could you have ever imagined that, one day, not in the so far distant future, that you would get a $19.7 million jury verdict?
I didn't even think I was going to make it through law school at a certain point. I remember showing up and looking around, and I didn't have any lawyers in my family. I didn't have any money. I mean, I waited tables the summer before I went to law school. And I remember getting to law school thinking, I don't belong here. Everybody here has got the secret playbook that I don't have access to. They know what's going on. I felt totally out of place. So to answer your question, no. But I'm super grateful that I've had, family. I had, grew up in a very hardworking family, learned how to work hard at a very young age and not to take anything for granted. So I'm just grateful that, I'm in this position to try to help people.
What was it, or who was it, or when was it that you just felt like you were meant to be a trial lawyer? Or was it something that kind of just, unfolded over time? Or was there more like a pronounced moment where you're like, no, this is what I want to do?
When about 3 days after my 18th birthday, my grandmother died unexpectedly. She committed suicide. She was let out of a locked psych unit where I grew up in Massachusetts, and she shouldn't have been. And she suffered from bipolar disorder, and she was suicidal, and she was a wonderful, beautiful person who helped raise me. And she was let out based on an error that was made by a doctor. And we tried to call lawyers to take the case, and we encountered just these lawyers that didn't care and didn't seem to want to hear it. She was older, she was this, that, and I remember feeling so hopeless and angry because I didn't have any exposure to lawyers. I'm like, why don't they understand how important she was to us? They seem to just be looking at this so dry and so heartless. That was the first moment that I thought, maybe I could do this. Maybe I could be a lawyer. I still didn't think I'd be able to, but it was in my mind. Maybe I could be someone who actually does care.
Yeah, I'm really sorry to hear that. That's that's an awful story. And to lose somebody that, just imagine losing my grandma under those circumstances. And so that was a big factor. Just, maybe you can, be somebody that if somebody, the tables were turned, came to you, you would be able to help them in this capacity.
Yeah, for sure. Yeah.
So you obviously, you get through school, that's, you kind of have, throughout school, at least you had that kind of, guidepost that you were aiming towards becoming, a plaintiff's trial lawyer that could help people that were injured or, had terrible things happen to them or their family members, right?
Yeah.
And so, can you walk me through sort of, whether it was methodical or it was more just kind of learning as you went? I like to think sometimes, like, if there are people listening and going back to that law school moment and they want to do what you're doing and they want to, get close to being an accomplished trial lawyer and maybe one day obtaining a great verdict, what were the steps that you took that you would, give as advice to somebody else that wants to go that route, be it seminars or affiliating with other, good trial lawyers or just forcing yourself to get into court? What advice would you give a younger lawyer, wanting to get, to where you are?
Yeah, I think being a pest and bothering other lawyers that try cases and following them into the courtroom, those are all things that I did in law school, and I just couldn't get enough of the courtroom. I loved the drama of it, the excitement, and so I would just say get in there as much as you can and then do what your law school offers in those fields. So I did the trial team at Temple Beasley School of Law. I took every trial ad class that I could, including some with federal judges, one of whom later wrote me a letter of recommendation for a job, having seen me on my feet and talk and whatnot. So I think just immerse yourself. I read books that weren't assigned to me about trial. I was really a nerd about it in some ways, but I wanted to I used to play baseball. I was a pitcher. So I treated it like a craft that I was trying to learn how to, both pick up things from other lawyers that are really smart, but also equally important is to maintain your individuality and your authenticity, because you've kicked butt in a courtroom. I mean, you have to be yourself in the courtroom in front of the jury. You have to be, right, to be authentic and for them to trust you and whatnot.
Yeah, no, I totally agree. Although, I'll tell you, I have tried a lot of cases at this point, but am very, I think, still trying to always figure out, like, what is the best way to, like, what is your authentic self? Like, who are you? And, how much of it do you share with the jury, and how much is there that sort of, level of some degree of restraint and so forth? So, yeah, that's always a perpetual process. And I think what's interesting about it is I sort of find, I think I'm almost my best version of myself a lot of times in court, at least when things are going well. When I'm in the right flow state, it's like the best version of me. A lot of times when it's not going so much, then I'm probably being an asshole or being a jerk and not really consistent.
I know that feeling too, yeah.
Yeah, it's peculiar how you can almost sense it. Like, yeah. But,
well, it's a weird thing to be like, I don't know about your experience, but I remember the first time I stood up in front of a jury in Bucks County, Pennsylvania, and that feeling of just looking at like 24 eyeballs staring right back at you, right? And just knowing you're being evaluated, you're being judged, you're the focal point in many ways. And you're the voice of your client, so I think it's interesting to have that role because it's an important one.
No, it's huge, and I'm a huge Rick Friedman fan, and he's been talking a lot lately about sort of the double sword of the messenger. So like on the one hand, you as trial lawyer are the most important person in the courtroom, but you're also the least important. You know what I mean? Because you're basically a vessel of how to tell the best story. And if you get caught up with, am I dressed the right way? Do I look the right way? And what about this? Then you're kind of missing the point of the whole process. On the other hand, your credibility, the way you present yourself, the way you carry yourself is incredibly important on the flip side. And I think that, just kind of keeping those two things, that balance, is unique to trial law. I can't think of any other places you really have to do that or have to do that. What, you talk about, being a nerd and that you've read a lot. Any, sort of formative or foundational books that for you, changed the way you thought about trying cases or had a particularly big impact on the way you try cases?
I'm going to forget the name of this book. It's an old one, and it's something cross-examination is in the title somewhere. I think it's called On Cross-Examination. Or wait, I think it's The Art of Cross-Examination. But anyways, it's an older book, like early 1900s, I think,
Oh, okay.
or even like 1930s. But it's just like these old trial lawyers like telling stories in the courtroom. And I remember one of the lawyers, it was a defense lawyer in an injury case in New York, remembering a moment in the courtroom where the plaintiff had alleged an arm injury. They couldn't raise their arm a certain level, and the defense lawyer's cross-examining the plaintiff, and then in the middle of the cross-exam tosses an apple right at the plaintiff, and the plaintiff reaches up and grabs it. And I mean, I don't even know if that's true or if he made it up, but like he completely disproved the plaintiff in that one moment. And something about that, there was like a million stories like that in the book, but I think that book helped me to understand while you're being indoctrinated with all these textbooks and academic, stuff that law school is, to remember that the courtroom is a place of human interaction, and it's a fluid, dynamic, alive place. And I think that's a really easy thing to lose sight of when you're in law school.
Yeah, I think that's a tremendous point to make, in the sense of like whenever you're late at night, you're mulling over, how are you going to cross a particular witness? And, some you're licking your chops, and other ones you're like, oh my God, I've got nothing on this person. But taking that sort of step back and thinking, is there, a completely different angle that you could make a compelling point, rather than just, asking, the basic standard type questions or basic approach. And I think that Apple anecdote, which I think I've heard or maybe seen on a television show, though, sort of speaks to that point. I think that's it's something to always keep in mind, when you're approaching cross-exam. But I want to, pivot now to, and I know you probably have lots of trial stories to tell, but I want to kind of, break down how your verdict, the trial went in the Melendez case. And I think, for those who haven't heard you speak about it, I've read a lot about it, and I've listened to you talk about the case before, but I, in listening, had a lot of follow-up questions I want to ask you about. But could you just give us a sort of a nutshell summary of what the case was, and also why did it have to be tried?
Yeah, so Diana Melendez was in her late 40s when she started going to her primary care doctor, Dr. Moe, who was a Penn medicine physician in Delaware County, just outside Philadelphia, and she had back pain and some tingling in her rib cage and abnormal reflexes. If you think of when the doctor hits your knee with the hammer, that's all that is. And it's a pretty simple test, but a really important one, because they're testing your reflexes. In other words, how well or not well is your spinal cord and your brain sending signals down to your feet and stuff, and are they in conjunction? So her scores were abnormal on that reflex test, and what followed from there was about 4-year period of time where Diana was going back and back and back to Dr. Moe with similar complaints getting worse over time, and he never sent her to any sort of specialist physician to look at her back. He never ordered an x-ray for her back. He never ordered a CAT scan for her back. He never ordered an MRI for her back. And she ended up kind of fighting and clawing her own way into a neurologist's office in 2017, about 5 years after she first saw Dr. Moe, and was diagnosed with a rare but dangerous mass in her spine called an AVM, which is just short for arteriovenous malformation. It's the best way, and you've probably seen this, but for those that don't know, it's kind of an abnormal cluster of blood vessels. You can get them in your brain or in your spine, and they're bad news because they cut off blood supply. And if you cut off blood supply to your brain or spine, that's not good. And the tissue dies over time. And so what happened with her was she became what's called an incomplete paraplegic. So she was able to walk, but not without a walker. Her bowels and bladder became neurogenic, meaning she had major problems using the bathroom on her own. She lost control of those functions. She lost her job, which ironically was at Penn, She was an excellent employee for over a decade in their lab department. She would run blood samples and tissue pathology samples from the hospital, and she was that person. And so she ended up out of work in her mid-50s and disabled. And she was actually the first case I was ever assigned as a lawyer after my clerkship. And it was, I mean, I met her when I was really wet behind the ears in a Starbucks. And we were together ever since. But the reason the case tried, and I'm sure we can get into that more, was because the defense didn't want to pay what we were willing to take. And ironically, we were very close in settlement, but just not close enough. And the verdict was substantially more than what they were willing to pay. And it was a true test in holding your ground. And as you know, there's always that balance between what's best, whether to try a case or not, and it's always what's best for the client. In this case, she was comfortable going forward and, obviously seeing how things went throughout the trial, because as you know, cases can settle during trial. And Penn just never once budged off their settlement offer that they made right before the opening, despite the fact that it wasn't going too well for them.
Yeah, from the way I've heard you describe the case, basically, not over, and I want to ask you your thought process behind this, but you called Dr. Moe as the first witness, and it sounded, based off the way your exam went, that, the case was really going in your favor, that he lost a lot of credibility, and that you were probably ahead at that point. And I've talked about this before with many other people, that I think sometimes the great verdicts there's a lot of luck too. Obviously, we work hard, and there's no doubt, you put on a magnificent case and did wonderful things, but there's also luck behind it. The fact that they never did offer you more money, is one of the reasons why you were allowed to get there. Did they, was there an adjuster there watching during trial, or had they just kind of made their mind up, this is the number, and, come what may?
So anybody listening who does plaintiff's work is going to be unsurprised by what I'm about to say, but including you, Brendan. But they sent their in-house lawyer, who was nice enough to sit there every day and open the door for the jury as they went in and out and smile at them, like your grandmother at church on Sunday. But after I cross-examined the doctor, he was impeached probably 15 times. And on very big points, and I felt that his credibility was zero. Yeah, but you, of course, you never know. You have a feeling, but you don't know what everyone else thinks. But what a lot of people probably don't know is that the judge brought us being the defense lawyers, that in-house lawyer who writes the check, and me, back into chambers right after my cross-examination ended, and off the record and without quoting the judge, because I don't remember exactly what words he used, was something, he looked at Penn and the lawyers and said, you guys might want to reconsider your position. And they were not apparently in the same courtroom as all of us, because they were like, oh, we think he did great, and we thought, and the judge who was very experienced plaintiff lawyer prior to becoming a judge, so somebody who had been in the courtroom and evaluated good clients, bad clients, good cases, bad cases. He was trying to get them to move, and again, without getting into the weeds, the distance that they had to move to get the case done was very short. It wasn't a big distance. But their heels were dug in, and it's an example of what I see a lot in cases, which is that the insurance carriers and the defense lawyers, not all of them, but many, and I would even say most, are not really operating in the same reality that we are and that the jury is most of the time. They're operating in this bubble where they look at people's lives in a very linear, sterilized, and formulaic manner, and they have their little spreadsheets and their calculations and their algorithms for why somebody's life isn't worth that much. But it's just not really how people think about these things. And so I think, to your point, a lot of trial lawyers will tell you, and I'll say it too, is like, yeah, you get lucky when they force your hand and you go to trial and you have a good case and it goes in well. That's sometimes all it takes.
Yeah, I think you summed it up perfectly, of them being in sort of an alternate reality that works a lot of the time for them. I mean, it's more statistically based, it's data based, and look, this is the box that your case falls into, and this is what we pay on those cases until proven otherwise. And, sometimes you get fortunate enough to be able to try that otherwise case, which you certainly did here. Let me dive into a couple questions I had about calling Dr. Mo first, okay? So I'm sure you've been at different seminars or riffed with other lawyers. There's always this debate of, do you call the key defendant in your case in chief, or do you wait for their case and call them then? Historically, I've always been in the camp you're in. Call them in your case in chief. My partner Greg and I battle about this. I still remain pretty staunchly in that camp. Now, that said, what I want to know, well, let's stick with that one. Why did you call him first? In this particular case, is that your default? Always, call the defendant Dr. as on cross, or is it case specific, and why in this case?
I wouldn't say I have a default, but historically I've always called the doctor as on cross first, like you said. It allows you to control the narrative. It allows you to avoid the dog and pony show that you see a lot of times with a direct exam of a doctor, where they're talking about how their great aunt had cancer when they were 3, and completely irrelevant stuff that's pulling at the heartstrings of a jury that you don't object to fast enough, and you don't want to be a jerk, that whole thing. You can avoid all of that, and you can put the doctor up. And in this case, my analysis was pretty simple. It was, he had given me some pretty straight admissions as to concerns that he admitted having back in time, back when Diana was caring for him, that she may have a spinal cord problem, right? So there were some clean admissions that I wanted to get in front of the jury. And then second was that his excuses, I call them excuses, not defenses, because
100%.
There are such thing as defenses, but I consider a defense to be something that has merit. So excuses are just, we all have them. And
right.
Put it that way. And he was saying basically that, these 2 critical points in her treatment history where there were neurologic abnormalities documented by him in the records, where he should have done something but didn't. Both he had these. The first excuse was that, and this goes to the reflex test, that he had clicked the wrong number 4 separate times. Because he did a reflex test of her right knee and her left knee, and her right ankle and her left ankle. So that's 4 total tests. And all of them were documented as 4+, which is the highest number on the reflex scale score you can get. 0 and 1 are too low. 2 is right where you want to be. 3 is a little high. 4 is like hyper-reflexic. And she got 4+, 4+, 4+, 4+.
And that's a red flag.
Of course. And his whole thing was, oh no, I vividly remember in 2012, she had 2 pluses, Mr. Bosworth. She had totally normal reflexes, but when I went on the computer with my mouse, I clicked 4+ accidentally 4 separate times. And I just thought from the whole case that was absolute hogwash, to put it lightly. And I didn't think anyone was going to believe him. And so I wanted to get that right in the minds of the jury, right up front. And I did that with the old-fashioned easel, which I love easels, and a red Sharpie. And I drew the 4 boxes on the easel. Well, actually, there's 5. 0, 1, 2, 3, 4. And I had him admit to the jury that each of these boxes are alongside each other. So if you were just going to miss 2 to the left, you would hit 1. Right? And if you went to click 2, but you missed on the right a bit, you'd have hit 3. But if you were to hit 4, not only did you miss 2, but you missed 3 right next to it and smacked 4. And you're telling us that you did that 4 separate times. And I think that after, he was married to it in front of the jury, and I don't think anybody believed him. And so the second thing, with the second neurological documentation years later, he claimed that the word neurological, which was, he documented she had neurological weakness, that she didn't have neurological weakness, that really he just put he put the word weakness under the constitutional section of the medical history, which relates to just general weakness, but due to a, quote, pen-wide software glitch that everyone had encountered, the term weakness got magically auto-populated to come after the neurological section of the exam. And I did discovery on that and confirmed there's never, ever been such a thing at Penn of any doctor. And they have an IT department, and if things like that happen, they get reported. And there's no evidence that that was ever actually a glitch in the system. So that was a long answer to your question, but those things are what I wanted to get in front of the jury pretty immediately to show not only that he was negligent, and not only that they're not taking accountability, but beyond that, they're selling you a story, and they're really insulting your intelligence by trying to tell you that these are really the things that happened. We all know that's not what happened.
And I want to, I have a follow-up on it, but I want to compliment you, and I think it's a great teaching point for every lawyer, but certainly young lawyers, what you did when you're confronted with, he testifies that, there was this hospital-wide glitch, and that in and of itself sounds so farcical. I think a lot of attorneys would have just said, that's enough, no one's going to believe that. However, you took, it sounded like multiple depositions, maybe a corporate rep deposition, to completely knock out and confirm that there was absolutely, that was not the case, that there was no firm-wide glitch, and this was really just a bunch of baloney, and there was no basis for it.
Well, on that point, and this goes to what you just said, I did take a corporate rep deposition who confirmed that there's no such evidence. And as you know, in trial, sometimes things happen that you have no way to prepare for. So in this case, I called that corporate witness right after Dr. Moe. And my plan was to get up there and have him, right after Dr. Moe, tell the jury we have no evidence of anything, basically, that Dr. Moe just swore up and down happened, no proof of it. I get him up there on the stand, and I'm crossing him, and I have my quintessential admission lined up from his deposition. And I go, and sir, the fact of the matter is, when you went looking for any evidence of this software glitch that Dr. Moe told us about, you found a total of 0 documents to back that up, correct? Expecting him to say, correct. Instead, he says...
Because that's what he said in his depo, right?
He says, no, there's definitely documents about that. Mr. Young and I were looking at them just yesterday. Mr. Young being the defense lawyer. Now, not only had I taken a corporate debt in discovery on this, but I had served interrogatories and gotten a court order because they objected to produce any such documents, and they responded, none.
And they had a duty to supplement.
Yep. And here I am in the middle of a trial, and I know you've been there, where you're like, holy smokes, this is happening in real time. What do I do? Do I go to sidebar now? Do I keep moving? Because I had great momentum in the cross. But at the same time, he had just blurted out something that was, from my understanding, completely untrue. And the jury's hearing now that there's this corroborating evidence. So I waited until a break, and then I brought it up.
Well, did you impeach him, though, with what he said in his deposition?
I did.
Okay.
I definitely.
And how did he justify that?
I think he said, like, at the time I hadn't seen them when you deposed me, but Mr. Young showed them to me a couple days ago. I mean, I think that explanation stunk to high heaven as it was. But it was unfair and untrue, because the truth was there were no such documents. So I raised a fuss on a break with the judge when the jury is out of the room, and the judge looked at the defense lawyer kind of like, yeah, what's the deal? And the defense lawyer walked over with this 3 documents. He gave them to me, and he's like, these are what he was talking about. I had never seen them before. They didn't actually corroborate Dr. Moe's story, which was like the other ironic thing. They were just like,
yeah. What did they actually show?
They were like screen clippings of like a computer screen, like as if you were the doctor going on to the template on the computer where they fill out the exam. It was just like a general like template of where the exam would be, but it certainly didn't show anything that Dr. Moe said it did, like there was some glitch. It's just basically if you screen clipped your computer screen. So right. I'm like, well, how do I deal with this, And so I'm saying to the judge, Judge, I would ask that you instruct the jury immediately that I forget what I asked for. It was an adverse inference instruction of some sort. he said, and the judge was like, "Oh, I'll take it under advisement," and we kept moving. But the very next witness, said the same thing. That he had seen the documents. And
Who was the third witness?
it was the chair of the healthcare the employer. It was like a practice group entity, and it was the chair of that entity who had verified the written discovery responses, saying we don't have anything.
Gotcha.
So my question to him was the same. Like, you went, you looked, you didn't find anything. It was the same question I had for the corporate rep, and he said the same thing. And at that point, the judge was not thrilled. And we went on another break, and he's like, to the defense lawyer, like, we just confirmed that this wasn't going to happen again. Because before that guy took the stand, I said to the judge, can we confirm with the defense counsel that's not going to happen with the next witness? They're not going to be talking about these documents that have never been produced and certainly don't actually corroborate the defense. And the judge looked at the defense lawyer, and he said, yes, that's true. And then the guy went right ahead and did it. So it all ended at the end of the trial, where the judge was basically saying he was contemplating giving an adverse inference instruction. And what I said was, which the defense bit on this, which was just not intelligent, but I said, because I think they had the buzzword adverse inference in their head as being terrible. I said, Judge,
that was the worst. Right. Anything could be better than that.
And an adverse inference, all that does is allow the jury to infer that the evidence was bad. It doesn't require them to. But I said, Judge, and the defense was arguing the whole time, basically, we don't know why the witnesses said that, because there are no responsive documents. We complied with the discovery order. There aren't any. And I said, Judge, rather than, get into the weeds about this adverse inference, I'd be happy to execute a stipulation with the defendants that states that there are no documents. Sorry, I'm laughing thinking about it. There are no documents to corroborate the software glitch, as was testified to by Mr. Maurer and Dr. forget his name. And the defense lawyers and the corporate, they go in their little huddle, and then they come back and they say, we agree. And I'm like, you got to be kidding me. So then the last piece of evidence in the entire trial, after all that hubbub, was the defense lawyer, was the judge going, and so as the final piece of evidence, I won't say her last name, defense lawyer is going to stand up and read a stipulation to you, members of the jury. A stipulation is an agreed upon set of facts that everybody agrees are true. Go ahead, Miss Penn lawyer. Thank you, Your Honor. So there are no documents to corroborate anything Dr. Moe said about the software glitch, da-da-da-da-da. And so that was the last piece of evidence, and you can imagine what I did in closing with that. I mean, it was like a piñata. I was just all over it.
Well, isn't it? And that's amazing. And but it seems like when you get great outcomes, a lot of times there are those, I'll call them gifts, or just these really fortuitous things that you never could have imagined. You just couldn't imagine they would happen until that, kind of magical moment in trial. And there you have it. I mean, because I love, and I want to talk about this for a second. I love the way, I think what you were doing in the way of your order of proof. Okay. So and let me kind of zoom out here for a second. I'm a big believer in, at least, I listen to what all the other great trial lawyers out there say, and it's focus on your best evidence. And clearly, you knew your best evidence was this incredible tale. Well, it was on the one hand that, the reflex, documentation of 4+, it's just a red flag, just in and of itself. And now they have this incredible explanation to get away, which really almost makes it that much worse for them, because it's sort of telling to the jury, this is really bad for us, to the point that we had to come up with this farcical, excuse. But there were problem aspects of your case. I mean, there were, you had a lot of different landmines that you had to navigate. And so was that a big part of your strategy that, look, I know what the best, most compelling part of my case is, and that's how I'm going to tee up. The first basically 3 witnesses are all about this issue. It's like the defense is trying to get out of it. I'd love to hear sort of your thought process of, that whole concept and the way you approached it.
Well, absolutely. I mean, I agree with you 100% on all those points you just made, and that's what I was thinking. And I tend to believe, I don't pretend to be any expert or anything, but I tend to believe that trials really come down to credibility at the end of the day. And I knew that this doctor had no credibility and was committed to his stories, which didn't make sense. And I wanted them to see that up front, because I also think that in addition to not believing witnesses who lack credibility, I also think that juries infer that when somebody's not credible, they have something to hide. And I think when juries think somebody has something to hide, I think they did something wrong. And I think they probably did most of the time. I think that's human nature, right? And so, but to your point, there were massive holes in the case from a liability standpoint. I mean, I had, I was at a different firm at the time, and many lawyers way older than me expressed that the case was totally losable. They thought that we were going to lose, and I'm not saying I disagreed with them, but not every visit was that she made to the doctor was a back pain visit. There were sometimes she went with pink eye. I mean, she lost a slip that the doctor gave her toward the end of her care that was to go get an EMG, a nerve test, due to her leg issues, and that kind of caused arguably a 4-month delay in her getting to the neurologist. She lost the slip, and so the jury did put 6% fault on her, presumably for that. But I think that I established pretty early on that the doctor had messed up, and that he was not willing to fess up to any of it. And I think it's difficult for a lawyer and defendant to come back from that. I think people want the first impressions matter, and credibility matters. And when you're sitting in the jury box and you're missing work and your kids are at home and you're listening to some physician who's supposed to help people lie to you, it could be angering. And so I think I wanted them to see who he was as a person kind of upfront.
And did I hear, and maybe I misunderstood this, but separate and apart from her care provided by the doctors, the defendants, did she go to like orthopedic appointments where they weren't noting reflex issues at all?
Yes, that was a huge part of the defense. She was going because she had knee arthritis, like bad knee arthritis, like to the point where she maybe needed surgery. And so she was going to this Penn orthopedic doctor for knee injections, where they were at least documenting having done exams where there was no problems with her legs or back anywhere noted in like these 10 or 15 visits. And of course the defense brought that up any chance they could. And the only thing I did to address that, which really is all I could do, was, and it was the truth, was I asked my client on direct examination, because she told me, and this is what she testified to, he never did any exam. You go in the room, the assistant brings you back, you sit on the table, and he would come in, hey, how's it going? He would inject my knees and leave. But, you and I know this, but it's not common knowledge, is that there's a lot of template reproduction in medical records, right? They have templates to just say the same thing, but they didn't call that doctor, and he was never deposed. And he was an employee of Penn, the defendant. And so I think what I said in closing, and don't quote me, but it's kind of foggy, but I think I remember saying, and Miss Melendez told you that there wasn't any sort of exam like they want you to think there was with Dr. Denota. And you don't think for 1 second, if that were different, they wouldn't march Dr. Denota right down here to talk to you? You've never met him, and neither have I. Where is he? And defense lawyers might make fun of me for that, or point out, oh, why would you do that? I think regular people on a jury assume that if you have something to show, you're going to show it to us. And
right, he was in your possession. He was your guy.
He's your employee. Yeah. You literally can just call him, and they didn't because they assumed I wouldn't point that out. But I think I hope that worked.
Well, clearly it did. Can you run me through and the listeners through the overall sort of order of proof? Okay, so you've talked about Dr. Moe, then the corporate rep, then the chair of the group, all keeping the focus on the absurdity and significance of these the neurological weakness and the 4+ patellar reflexes. Where does it go from there? Like, what were your next witnesses?
So we also had a podiatrist who was a defendant in the case, but a much, much weaker case against him. And the jury found in his favor, put no liability on him. So I think we put our podiatry expert right smack in the middle of there because it didn't much matter to me whether they put anything on him. And so we kind of buried that right in the middle of the case in chief. And then what we did was I called our liability experts, internal medicine doctor to testify to standard of care, and then a neurologist to discuss causation. And then I ended with, I also called a records custodian from Penn and marched her through all of my client's employment records, which indicated that she was an excellent employee and also that she was disabled from work because of her spinal cord injury. Because the defendants, as stupid as this was, they couldn't help themselves but hire experts to come in and say, she's not disabled, she can work, she really can. The great irony being, they fired her because she literally couldn't work anymore. And the reason that they determined it wasn't knee arthritis, it wasn't anything other than a spinal cord injury. And so I had this documented, and they were having a fit because I was bringing it up throughout the case in chief, saying, it's not relevant, it's not relevant. And the judge was like, well, are you going to call these experts? And they wouldn't commit to it one way or the other. They were playing games. So they were like, well, we might. And he's like, well, as long as you might, it's in play, basically. And another error is that they then never called those experts. But if they had, I don't think they would have survived anyway. But I called that records custodian and put that in front of the jury. So, and it's like, here they are saying she's disabled. It's Penn. Like they say she can't work because of this. And so I said, I think in closing, there were a lot of courtroom conversions. So they took reality, and then the lawyers said, well, you're not really seeing what you think you're seeing. And then I ended with the client who actually got COVID in the middle of the trial, by the way.
I heard that, and there was a move for a mistrial and that whole, mess.
The defense lawyers were jumping for joy when she got COVID because I think they thought they were going to get a mistrial. And the judge, which I think was probably the right thing, said, I'm going to poll each juror individually because the client was like within feet of them. And it was, and the judge is like, I'm going to tell them like she's got COVID. And basically, if they're not comfortable proceeding, like I think we have to declare a mistrial. And the defense, they were all snickering in the corner, like thinking, here's a get out of jail free card for this jury. And one of the more powerful moments in the trial was watching each juror come in one by one, which I don't think anybody expected this because I was a little nervous too. I didn't know what they were going to do. And the judge explaining it and them saying, we're going to stay. We're going to stay. We're going to stay. What? Unanimous. And I watched their
probably not staying to hand out a D verdict, right?
Well, I walked up to the lawyer who was probably more than twice my age, one of the guys trying it, and I said, "Hey, I'm not like you've been doing this longer than me." I said, "I don't know that they're sticking around to zero her out." and he was like, "Oh well, that could be, Tom." So, anyway.
Did you call the podiatrist as on cross?
Yeah.
But at that point, did you pile the case more on to Dr. Moe, or did you still try to, establish the case against that doctor?
I didn't really even care at that point because really all his notes did for me was prove the case against Dr. Moe because his notes were a lot more thorough as to how significant the neurologic weakness and the numbness, and it was like L5 distribution of numbness radiating down the leg, blah, blah, blah. Like it was very, very thorough. And so I just really wanted to get that in the jury's mind from a chronological standpoint to say, look at how badly this has progressed and look how much he's missing.
And so you called that on cross. You use him basically to further establish the case against Dr. Moe. You have your liability experts. You call the records the custodian to establish, her disability through Penn.
We called a life care planner to testify as their medical needs.
Was that opinion based off of the neurologist's opinions, or did they do an independent exam and then work up the pricing and so forth?
Independent exam, went to her apartment, met with her, talked to her, that whole thing. And then I had a physical medicine and rehab doctor who testified by video about her injuries and blessed the life care plan as being reasonable and necessary. And then I had an economist talk about her future medical costs, past and future economic damages, not able to work anymore. And then I called the plaintiff virtually because she was home with COVID.
Oh, wow. Really?
Yeah.
Oh, I thought it was after she had testified that she was not able. Oh,
She never
interesting.
came back to the courtroom, and actually she listened to the verdict on a cell phone because she wasn't able to be there. So we asked the judge if we could patch her in when we got the verdict. And
Oh, wow. And I understand that you made the strategic decision not to call any other kind of condition witnesses, anybody else from her life to say, this is how, she was before, this is how she is now kind of thing.
only because she had some family. She's single and didn't have any kids, and so most of her family lived in New York, and so like there were some good witnesses to talk about how banged up she was. But my fear was that a good defense lawyer could do a nice cross on them in terms of how limited it is in terms of how frequently they see her, because like it would be like at Thanksgiving and stuff, and rather than kind of like inject that issue into the case, I think that because Diana is super credible in and of herself, that I just said I'm not even going to go there.
See, I think that was another really just wise decision on your part, because I'm sure you've seen it's been a thing for some time now. Everybody talks about how important condition witnesses are, how important the before and after are. And that is true in certain cases. But I think people hear it and they just slap it into every case, and they try to crowbar these witnesses into some case when it's not helping you. And probably it's going to hurt for the point you made, the bias, the, dragging the case on further. We already heard this kind of stuff type thing. Unless they're unique, they're not directly connected to them. And especially she had significant injuries. So it kind of, the records, the, employment records, her testimony, and what she goes through. And also you've got the nurse talking about what her life is like. Why would you really need to pile on anymore? It's almost gratuitous at that point.
Exactly.
So I think that was, that's just something I think really wise for people to keep in mind. You always got to, what does this case need, and what's going to benefit us? Let me take I want to kind of go in reverse order on a couple of things real quick. Number one, how was the jury selection process carried out, and what was the general makeup of the jury as far as you remember?
So it was general voir dire questions to the panel by both lawyers. Pretty basic stuff like, do you know me? Do you know my firm? Have you heard of my client? Followed by individual voir dire in a separate room of each juror after hardships were considered, peremptory strikes. So, yeah, it was an interesting jury. From what I remember, it was a fairly diverse jury, which is just how Philadelphia is. And so it was, I think we had 5 black folks on the jury, 2 Hispanic folks, the rest were white. There was a young college kid, which was interesting because there's all this talk about younger jurors and people have like lots of thoughts on him on that. And so he was like 22, still lived with his parents. I was like, and then there were there's actually this older gentleman in the front row who ended up being dismissed because he had like a wedding or something. And so an alternate took his spot, but he was this big, burly, looked like he was in the trades or something, like the kind of guy you don't want to get on the wrong side of. But remember during my cross of Dr. Mo, while Dr. Mo was being kind of impeached pretty badly, this guy in the front row like verbally blurted out like, what do you mean? Or something like, I forget what he said, but he was like so perturbed that he was like, it's right there. It's right there. And I remember I had never dealt with that, so I didn't know what to do because I didn't want to talk to him, but I looked at the judge and then I looked at him and I kind of like everybody just kind of paused for a minute. But it wasn't a great moment for the defense. But
oh my God, that's amazing.
Yeah,
but then you were probably pissed when he couldn't be your juror anymore, right?
You know what's funny is then he started giving me the side eye too. So I was like, is this guy just generally mad at everybody? So he was kind of a wild card. So when he
Fair point.
I was like, it's fine, that's okay.
Were there certain beliefs or certain answers to types of questions that you were looking for to get for people to be on your jury or not be on your jury that you thought were important?
I think the main question I probably asked everybody was, we're going to prove the case to you, but assuming that we do, are you going to be comfortable and capable to adequately award money damages for Diana's pain and suffering, both the pain and suffering she's endured in the past and into the future? Because, and the way I do voir dire, I'm very open and vulnerable, and I'm not trying to win one over on anyone. I'm trying to get people to be honest, even if that means that it's bad for me. I want people to feel comfortable being honest. And so I like to tell jurors, I have thick skin. There's nothing that you can say that's going to hurt my feelings, but we do need to know how you feel about some things, because it's important to everybody here that we know how you really feel. And so I liked to gauge how people answered that question, because even with body language, I think you can learn a lot about how someone might view pain and suffering and whether that is substantial to them or not, because you obviously can't suggest a number to them for those sorts of damages. And I knew that the boardable damages we had, the lost earnings and the medical expenses, weren't really attackable. So I think I learned a lot of data from that question.
Was that in the individual voir dire portion?
Yes.
So you're given an opportunity to kind of interact with them, ask the questions you want and so forth.
Yes. Yeah.
Okay, interesting. Want to jump in just briefly. Can you share your approach specific to, medical malpractice cases? Because I think they're such a unique animal. Generally, how you approach the screening process. Like, what are you looking for? How do you, when a case comes into the door, what are the things you're looking for as far as whether it meets your criteria? I know that's a very broad question, and every case is so specific. Let me give you a little, because I always remember other things that people said. So there's an attorney in Minnesota, Brendan Thompson, who was interviewed and talked about this. He does a lot of med mal. And I'm always just kind of interested, how people look at things. He said that their number one, the first thing they look at, no matter what, is, essentially, how significant are the damages.
Yeah.
That's like the starting point. And that they essentially don't go any further with the analysis if they're not sort of, very, very significant to begin with. Whereas, and I think that obviously makes a lot of sense for a lot of reasons, I look at it a little more of a bit of a continuum, if the damages aren't as bad, but they're just absolutely crushing or aggravated liability, then I'm more inclined to take it. If the damages are just off the charts, then I'm willing to invest the time to really next explore liability and so forth. But, I'm just curious about the way you look at cases.
I'm totally in your camp. 100%. Oh, and almost more so on the pendulum, maybe. This is just my philosophy. I think that conduct and behavior drives the value of a verdict a heck of a lot more than lawyers like to recognize. And that doesn't mean that you can have a stub toe and go get $5 million. But to your point, I think that juries feel the need to compensate when not just the damages are objectively bad, but the behavior is bad. And I really keep that in mind. So I've taken cases no one wanted to touch on that premise. I mean, I think of one where I tried in June 2022, 3 months before this one. It was a mentally disabled man with a terminal diagnosis of something called amyloidosis, which is like a death sentence. And he was mentally disabled, the mind of a 5-year-old, never earned a penny in his life, found with 17 fractures throughout his body after being left with a problem employee in the group home for 2 hours. Ends up internal bleeding, dying. Autopsy is a natural death from his amyloidosis. No suspicions raised, not whatsoever. This guy was abused. This guy, and I had an expert who believed it, a forensic pathologist. I mean, his sternum was fractured, his spinal cord was severed, his pelvis was shattered. I just didn't buy it for 1 second. And that's a case that had zero medical expenses as the damages, zero income. He had no children. His mom was an 83-year-old woman who didn't speak a lick of English. She spoke Spanish. And every lawyer in the world was like, if you get $1 million for that case, you are like out of this world. And I'm like, this case is way, way more about like a lot more to do with what you guys think it is. Like I don't care that he didn't make money. And I remember the first pretrial offer was $100,000, and then I rejected that. And then after opening, they offered $1 million, and I rejected it. And then throughout the case in chief, Tom, we can't go above 3, but no. And then I rested, I crossed their expert, and the case settled for $7 million after I crossed their first expert, who literally got laughed off the stand, which I've never seen. But the insurance president lady, whatever the heck her name is, called me and said, all right, we got your 7 after, I know you've been down this road. We're never going to pay you this much. Never. And then they do. So, but that's a case that no one thought was worth that. But I don't think I'm a genius or anything or any smarter than anyone else. I just think that those sorts of things, I think people were really like disgusted with it. And I think they believed he was assaulted and that it was covered up. So
yeah,
that drove the value there.
Out of curiosity, did you have a punitives claim in that case, or was it more, there was going to be punitives, right?
There was. They moved, when I rested, they moved to dismiss them. But this employee who he was left with had a horrific background and really should have never been hired. And I said to the judge, I think my whole argument on the non-suit was, Judge, I said, I love this restaurant, so no pun intended, but I think they do a better job at McDonald's at looking at people's background.
Right.
That was my whole argument, and he like denied it. And so then they were staring down the barrel of a punitives award. So, yeah.
Yeah, but with those facts, but I think they're probably going to build punitives into the compensatory anyway, even if you don't have it. And I'm with you. I really think, and it seems at least lately, I kind of nerd out on some of the big data studies that are out there and focus groups that jurors are much more inclined to, larger verdicts are going to come when there are people not, like you said, your theme in opening, accountability, but almost sometimes beyond accountability, either deception, lying, really trying to shirk responsibility, or just reprehensible or crappy behavior. You know what I mean? Those are the things that are driving the cases. And that's why, you look at the big damages model, but if there's just something really compelling and I think really what it boils down to is like, do you want to stand up for that person? Because this is BS what freaking happened. And I don't even care if the damages aren't massive. This just shouldn't happen. I think other people, that's going to resonate with them. So a couple, last things I want to, kind of tie up because we're coming to this hour mark and you've been so generous with your time. Was their case in chief particularly long? And, did you, I know you went really long. You went like a day crossing Dr. Mo, but everybody else, were you, more punchy at that point? Because you kind of had the momentum going with yourself at that point.
I was trying to get to the jury as quickly as possible. I thought we had the momentum. They had very qualified experts. They had some guy, their standard of care expert in internal medicine was like the head of Harvard, and then their neurosurgeon was the head of Yale. And so, I really didn't have much to say to them because I wasn't going to fight them on the medicine. I wasn't going to go toe-to-toe with them on AVMs. So all I really did with both of them was point out everything that wasn't in the reports, which just so happened to be all the bad symptoms and all the concerning symptoms and all the neurological abnormalities that just didn't make it into their reports. And so I think that I dismantled their credibility quickly, and my cross was quite literally bringing up a medical record which says like, Diana has numbness in her waist, and then saying, and then saying, and a lot of them were pen doctors, so I'd say, and that's what the pen doctor said, isn't it? Yes. And I said, and that didn't make it into your report either, did it, sir? That was like literally like over and over and over and over and over and over and over again until I think it sends the message of, okay, so you just wrote a report. It's complete. Your report's just totally just outcome determinative. We don't believe you. I don't care that you're from Yale. You're leaving out all these important facts.
Well, and I think, that kind of the way you approach that sort of, reminds me, coming full circle back to, the catching the apple anecdote from the beginning when we first started talking, that, part of you is like, oh, I've got to, go after this guy on the medicine. But then you're looking like, well, geez, he's the freaking, head of neurosurgery at Yale or the head guy from Harvard. I'm never going to win that battle. But, if you look at the inverse, what isn't there? What's missing? What didn't they talk about? And they've got no argument to that. You know what I mean? But it's just kind of like reframing the way that you're thinking about approaching your cross, which I think was so brilliant the way that that you did that. And I think it's a great way, just a simple point to always keep in mind, like what's missing, what isn't there, what's that low-hanging fruit that everybody's going to, resonate with on that journey.
Another thing too, sorry if I could just really quickly just...
No, please.
So with this neurosurgeon, Dr. Dickey from Yale, I mean, he didn't have a great grasp on the facts. I mean, he was obviously qualified, super big credentials, but I can't say enough about knowing your case file, knowing the facts like the back of your hand, because it wasn't until his direct exam that, he and the lawyer were trying to make the point about how, every time Diana had a problem with her legs or back or whatever, yeah, it was an issue, but he always had a but. But it wasn't really actually a concern because A, B, and C. And one of the big buts for him was, yeah, but she didn't have gait abnormalities. Yeah, but she didn't have gait dysfunction, meaning like when you walk, right? And, she had been going to physical therapy, and he obviously didn't look at these records at all or closely. She had been going to physical therapy for her knee arthritis, and they had documented repeatedly she had gait issues. So I was just like scribbling on my yellow pad during direct, and I had the chart, those records set up, and so I set them up when I got on cross. I think something like, doctor, I think what you were trying to tell the jury was, you weren't terribly concerned about Diana's back pain, but golly gee, if she had gait problems. Did I understand that correctly? And he was like, oh yeah. And then I just smacked him with the gate references over and over and over and over again. And then he flew back to Connecticut.
You're right. Exactly. Perfect. So, in, wrapping this up, but in closing, any, go-to or sort of, particularly poignant, damage arguments you made that you can share, or was it really, kind of very case specific?
I guess the one thing that comes to mind when I started to talk about damages in closing was, and I think it's good for us as lawyers to keep this in mind, and I forget it a lot of times, is like, we've been in the case for 3-4 years. By the time it goes to trial, most, if not all, jurors have no clue what goes into the length of time. And so I think what I said to that jury was like, this is the last time we're ever going to be together. And whatever decision you make today will have, one way or the other, will have a lasting impact on the life of Diana Melendez. And this is her only shot for true and full justice. And in 15 years, you all might have grandkids you don't have now. Who knows where I'll be? Who knows where we'll be? But Diana waited 3-4 years for you. You are the jury that, you might not have realized this when you got picked. You're it. You have a tremendous amount of power here, and really a responsibility to speak loudly and clearly when you arrive at your verdict. Because I wanted them to understand the permanency of it and the importance of it, which I think is always hard to do, because people have lives, jurors have lives, and they're sometimes itching to get out of there, but they have to be reminded, I think, that it's really important.
Great power comes great responsibility, right? How long was the deliberation?
I forget, honestly.
Any questions?
I think they asked, they did ask for like the economists, like all of his whole like report and like his numbers, which
always the best question,
like,
right?
Okay, I'm okay with that.
And no change in offer at that point.
No, they were like so adamant. I don't know. Who knows? Yeah.
Crazy.
Yeah.
Well, good for you. Lucky. I mean, again, and not lucky. I mean, you guys earned that case, but that's just phenomenal. And I mean, how'd you feel when they started reading those numbers off and you start putting it all together? What just happened?
I just felt really overwhelmed with emotion, and I was happy for Diana, because she'd spent so much time like second guessing herself and being like, am I crazy? And being kind of dismissed by Dr. Mo for all this time, I think it was really good for her to hear that, oh my gosh, all right, this 12 people in my community, like, totally see this for what it is.
Yeah, and I think that's an amazing part of the verdicts that people don't think about a lot of times is, obviously you hear this monster verdict, giant amount of money and so on and so forth, and that becomes kind of the focal point. But when you're in that moment with that person that's been through this, and they're, like you said, like they're like, am I crazy? Am I maybe just getting this totally wrong, that I'm being irrational? And then, in a righteous case, they get, they're affirmed. 12 people come back and say, no, Diana, you were right. You were totally right, and this shouldn't have happened. I mean, that's honestly, I think, one of the biggest kind of like most cathartic, therapeutic aspects of these cases, when things work out the way they did in this case. So I think it's amazing. And congrats again. And so I just want to, wrap up, before we were, went on, you were telling me about a pretty fascinating new case or new cases, I guess, potentially that could be happening here. But I know you got, like I said, a lot of irons in the fire you have, but what's hot on the presses right now for Tom Bosworth?
Other than trying to raise a 3-year-old and a 1-year-old, which is a full-time job.
Been there, done that.
Well, I might have to get your advice offline on that. But yeah, no, I was just hired this weekend, actually. So 2 days ago, in a case involving a pediatrician in Lehigh County who was recently removed as the head of Lehigh Valley Health Network's Child Advocacy Center, which is basically where all possible child abuse cases get evaluated by a pediatrician. And unfortunately, this physician has a nearly 2 decades long history in multiple states, including New York and Florida, of just misreporting, misdiagnosing, and outright making inaccurate allegations against parents saying that they've abused their children when they have not. And it's resulted in a lot of families being separated, a lot of kids being placed in foster care. And in this one particular case, my client, who's a single mother of 5, had her children removed for 4 years based on an unsubstantiated claim that she had abused her kids, and the damage that this caused the children, without getting into the details, was horrible. I mean, they were put in foster care where they experienced things that no child should experience. So they've lost a big chunk of their childhood, and they've permanently lost their innocence because of this one person who had too much power, who probably should have never been in the position she was in. So it's definitely a case that I care deeply about, and it just came on my radar, so that's what I'll be doing, other than picking a jury on February 1st.
All right, man. So you're hopping right back into court coming up.
Yep.
Well, I wish you the best of luck with the upcoming trial. That big case is going to be coming out. People want to reach out to you, talk to you, have you represent them. What's the best way for people to find you, Tom?
So my email, which is Tom Bosworth Law. That's B as in boy, O S as in sand, WORTH law.com. Tom at tombosworthlaw.com. My phone number's 267-928-4183. And if you're on TikTok, which I kind of make videos on there sometimes, it's Tommy the Lawyer is my name on there. So.
No, I think you're doing awesome with that. I don't know I think I've missed the TikTok bus, but I admire how well you're doing all of your social media presence, and you're just really kicking butt out there. I wish you the best of success, man.
Thanks,
you don't even need it.
No.
I know you're gonna continue to knock them out of the park, and maybe we can talk again when you hit your next big verdict. Okay?
For sure. Thanks, Brendan. I appreciate it.
Heck yeah, man. Thanks for doing the pod.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.